Hi guys, we are still here live in Abuja. Nnamdi Kanu, Judgement Day. Still waiting for Justice James Omotosho to say what he wants to say. He's still reading, he's still talking. So we are still live here. Please keep on, following us, because today the word go see through. Even the spirit go see through how this judgment will be given. So guys, stay tuned. We'll be right back.
Of the land, it would have been different if the defendant's offenses were allegedly committed after the Terrorism Prevention Act 2022 have been enacted. The Terrorism Prevention Amendment Act 2022 comes into effect on 12th day of May 2022, which is a later date compared to when the alleged offenses were committed. The Supreme Court in Federal Republic of Nigeria versus Kanu Supra, the present defendant in this case also ruled on that issue and held, and I quote, "Now, even a casual look at the offenses stated in count 1, 2, 3, 4, 5, and 8 of the charge pleaded to by the respondent before the trial court readily shows that they are offenses provided for in 2011 Act as amended and by the 2013 Act, under which the charge was filed and brought, and the respondent was properly and validly arraigned before the trial court. Put another way, the offenses the respondent was arraigned for before the trial court are offenses known to and specifically provided for under and by the provision of 2011 Act as amended by 2013 Act. The offenses are therefore recognized, cognizable in law, to be legally grounded and backed by the provision of extant and existing law that was /is in force at the material time and now. On its part, count 15 of the charge is indicated to be contrary to section 47(2)(a) of the Criminal Code Act, cap C45, Laws of the Federation of Nigeria 2004. There can be no reasonable dispute that the Criminal Code is an extant and existing statute or act that was or is in force in Nigeria, which the court has the duty to take judicial notice in this appeal, pursuant to provision of section 122 of the Evidence Act 2011. In addition, the court is also entitled to take judicial notice of the codification and publication of all the acts or statutes, the subsidiary legislations, enactments, or passed by the National Assembly as contained in the laws of the Federation of Nigeria, published by or under the authority of the Federal Ministry of Justice of Nigeria at various times, because we here are concerned with laws of Federation of Nigeria 2004, in which the Criminal Code Act is indicated to be. I have noted and pursued the laws, perused the law and acts codified and published in the laws of Federation 2004 as published. The Criminal Code Act is published in Volume 4, comprising of Chapter C24 to Chapter C48. It is in Chapter C38, which is subsequently indicated as Cap 38. The Criminal Code Act is in Chapter 38 of the Laws of Federation of Nigeria 2004, and it's also called or shown to be Chapter C38 in Volume 4 of the publication. It is apparent, therefore, that the Criminal Code Act is not Cap 45 or Cap C45 in Volume 4 of the Laws of Federation of Nigeria, as indicated in count 15 of the charge against the respondent. Rather, Criminal Code Act is Chapter 38 or Chapter C38 in the Laws of Federation of Nigeria 2004. However, the same Laws of Federation of Nigeria 2004 Chapter 45 or Cap 45 is the Custom and Excise Management Act. A calm reading of the details of the facts stated as constituting the offense mentioned or named therein will clearly and undoubtedly reveal that it deals with offense punishable under the provision of Section 47(2)(ba) of the Custom and Excise Management Act C-45, Laws of Federation of Nigeria 2004, which provide as follows. 47(2) if any person A imports or causes to import any goods or conceal in a container holding goods of different description, he shall be sentenced to imprisonment for 5 years without the option of fine. It follows, in the above circumstances, that the mention of the Criminal Code Act as being Chapter C-45 and C-45 in Laws of Federation 2004 is a mere mistake in place of correct law. The Custom and Excise Management Act, under which the facts alleged to constitute an offense in Cap 15, is punished or punishable. The offense in Cap 15 is consequently recognizable, and grounded in an extant existing law in Nigeria, in which it was defined and described. It is now on-book law that a charge preferred or filed for offense under a wrong law will not be rendered invalid or incompetent merely on that ground alone, so long as the offense on the charge are known to defined and punishable punishment provided for in an extant law. In the results, the answer to the answer posed earlier in this affirmative in both two counts, that the Terrorism Prevention Amendment Act 2013, under which the offences of count 1, 2, 3, 4, 5, and 8 as well as Cap C-45 and Cap C-45, Custom and Excise Management Act, all contained in Laws of Federation of Nigeria 2004, are extant and existing law, which provide for, under which the offences in the counts of the charge retained by the trial court are punishable and punished. The offences, once more, are recognized, cognizable, and ground instant and existing law in force in Nigeria. Assuming without considering that at the commencement of the Terrorism Prevention Amendment Act, the Terrorism Prevention Amendment 13 was repealed, and such is liable to affect the validity of the defendant's trial. I refer to Section